Hi there, I will be reading the Evidence Reviewer of 2019 and 2020. Evidence defined. Evidence is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. Elements of evidence are means sanctioned by these rules to ascertain the truth respecting a matter of fact in a judicial proceeding. Proof versus evidence. Proof is the result of evidence. Proof is the end result, while evidence is the means by which the proof is established. Evidence is the means to the end. The rules on evidence determine the following: 1. Relevancy of facts. The sort of facts may prove in order to establish the existence of the right, duty, or liability defined by substantive law. Number 2, proof of facts. What sort of proof is to be given of those facts? And number 3, production of proof of relevant facts. That is, who is to give it and how it is to be given, and the effect of improper admission or rejection or evidence. Factum probandum versus factum probans. Factum probandum is a proposition to be established, is a hypothetical one which the party affirms and the other denies. In factum probans, material evidencing the proposition. It is existent. It is offered as reality for the purpose of convincing that the proposition is also a reality. Classes of evidence. As to the requirements of admissibility, 1 must be relevant. An evidence is relevant when it has a tendency in reason to establish the probability or improbability of a fact in issue. That is, evidence that a reasonable mind might accept as adequate to support a conclusion. That is in Marcel versus Bangubong, GR 175201, April 23, 2008. The test of relevancy is determinable by rules of logic and human experience. People versus Galeno, GR 123546. Number 2. So number 1 is relevant. Number 2, competent. Evidence is competent when it is not excluded by law in a particular case. As to nature, testimonial. Testimony of a witness, usually on oath or affirmation, given by his word of mouth in the witness stand. Number 2 is documentary. Evidence consists of writings, recordings, or any material containing letters, words, numbers, figures, symbols, or other modes of written expressions offered as proof of their contents. That is under Rule 130, Section 2. Number 3 is object. Evidence which proves the fact in dispute without the aid of any inference or presumption. It is that which is addressed to the senses of the court. Section 1, Rule 130. Now, as to its ability to establish the fact in dispute, number 1, direct. Evidence which proves the fact in dispute without aid of any inference or presumption. People versus Fronda, GR 130602. Number 2 is circumstantial. Proof of facts from which, taken collectively, the existence of the particular fact in dispute may be inferred as a necessary or probable consequence. Example, testimony of X that he saw A running away from the place where B is found dead. Clothing of A stained with blood, bullet of A stained with blood. That is circumstantial. Circumstantial evidence is sufficient for conviction if the following requisites occur or concur. A. There is more than one circumstance. B. The facts from which the inference are derived are established. The letter C. The combination of all circumstances is such as to warrant a finding of guilt beyond reasonable doubt. People versus Pascual, GR 172-326, and that is in January 19, 2009. Now, D as to weight. Number one, primary. Evidence which affords greatest certainty of the fact in question. Example, the original copy of the contract of evidence as evidence of its contents. Secondary, evidence which is inferior to primary evidence and shows on its face that better evidence exists. Example, the copy of contract or testimony of witness as to the contents. As to the tenor of proof offered. Number one, positive. Witness affirms that a fact did or did not occur. Example, testimony of a witness X that he saw A set fire of the house of B. Number two is negative. Witness states that he did not see or know the occurrence of a fact. Example, testimony of X that he was on occasion at the place where the house of B was burned and that he did not see A set the fire on said house. Now, as to the nature of additional evidence, number one is corroborative. Evidence of the different kind and character tending to prove the same point. Example, testimony of X that A died because of stab wounds inflicted by B, corroborated by death certificate. Number two is cumulative. Evidence of the same kind in character as that already given tending to prove the same proposition. Example, on the issue of capacity of a boy to write a certain paper, the evidence of his classmates and that of his teachers upon the same question. Now, as to the degree of its value in establishing a disputed fact, number one is prima facie, that which suffices for the proof of a particular fact until contradicted and overcome by other evidence. Number two is conclusive, incontrovertible, or which the law does not allow to be contradicted. Section 2, Scope. The rules of evidence shall be the same in all courts and all trials and hearings except as otherwise provided by law or these rules. However, there are material differences between rules on civil and criminal procedure, to wit, like civil is a party attends by a court, no presumption as to either party, offer as compromise does not amount to admission of liability. The plaintiff must prove claim by preponderance of evidence, while under criminal, the accused attends by compulsion. Presumption of innocence attends to the accused throughout the trial until overcome by prima facie evidence of guilt. It is an implied admission of guilt when you offer a compromise. Government must establish guilt of accused beyond reasonable doubt. Section 4 of Rule 1 provides that rules of court do not apply to 1. Naturalization proceedings, insolvency proceedings, cadastral proceedings, other cases as may be provided by law, land registration cases, and election cases, except by analogy or suppletory whenever practicable and convenient. It is noteworthy to point out that owing to the initiatory nature of preliminary investigations, the technical rules of evidence should not be applied in the course of its proceedings. In the recent case of Estrada versus Ombudsman, the court declared that hearsay evidence is admissible in determining probable cause in preliminary investigations because such investigation is merely preliminary and does not finally adjudicate rights and obligations of parties. BDCIC versus Casimiro. The NLRC Rules of Procedure states that the rules of procedure and evidence prevailing in courts of law and equity shall not be controlling, and the Commission shall use every and all reasonable means to ascertain the facts, in each case speedily and objectively, without regard to technicalities of law or procedure. That is Buenaflor Car Services versus David, TR 222-730. No vested right of property in rules of evidence. The reason is that the rules are merely methods of ascertaining facts. For instance, any evidence inadmissible according to the laws in force at the time the action accrued, but admissible at the time of the trial, is receivable. Waiver of rules of evidence. As rules of evidence are established merely for the protection of the parties, they may waive such rules during trial. However, if the rule of evidence is established on grounds of public policy, waiver by the parties thereof is void. Example, waiver of privilege against disclosure of state secrets. The sources of these rules are the 1987 Constitution, Article 3, Section 3, 12, 17, and Article 7, Section 5. Revised Rules on Evidence, Rules 128 to 134. Bar Matter number 411, dated March 14, 1989. Rule 115, Section 1. Substantive and remedial statutes. Judicial decisions and rules on DNA evidence. Question: during the trial between A and B in January 2, 2020, as evidence of the correct amount of purchased items and consideration, presented a photocopy of the contract of sale between him and B, which is the subject of the civil case. B objected, arguing that at the time of the execution of the contract in 2016, the rules of court only allows the original of the document sought to be admitted as documentary evidence. Since A could not proffer proof that the documents have been lost or destroyed, then the original must be submitted as evidence. Otherwise, the copy thereof is inadmissible. A, on the other hand, argued that at the time of the presentation of evidence, the rules of court was amended in 2019 to the effect that copy of original documents sought to be admitted may be received in evidence, provided an affidavit attesting to the veracity of its contents be attached thereto, subject to cross-examination, which affidavit was made by A. Decide. The answer is the evidence must be admitted. Every evidence inadmissible according to laws in force at the time the action accrued, but admissible according to the laws in force at the time of the trial, is receivable. Here, had the evidence been presented before the amendment of the rules of court in 2019, then the contract A sought to be admitted shall not be allowed. However, since the evidence was presented after the amendment and that the conditions for admissibility was fulfilled, then it must be admitted as it complies with the rules prevailing at the time it was presented. Section 3, Admissibility of Evidence. Evidence is admissible when it is relevant to the issue and is not excluded by the Constitution, the law of these rules. In order that evidence may be admissible, two requisites must concur to it. 1, relevant to the issue. 2, competent, that is, does not belong to that class of evidence which is excluded by the Constitution, law, or rules of evidence. Admissibility of evidence versus weight of evidence. Weight has to do with the effect of evidence admitted, its tendency to convince and persuade. It depends upon its effect in inducing belief on the part of the judge trying the case. Admissibility refers to the question. A. Relevancy of evidence. Evidence is relevant when it has such relation to the fact in issue as to induce a belief as to its existence or non-existence. That is, under Section 4, Rule 130, it depends upon its tendency to establish a controverted fact. Materiality of evidence. Evidence is material when it is directed to prove a fact in issue as determined by the rules of substantive law and pleadings. It means its quality of substantial importance to the particular issue apart from its relevancy. Some authorities treat the two as having substantially the same meaning and effect. It could aptly be said that materiality is a degree of relevancy, that evidence which has but slight relevancy is immaterial. They are often used interchangeably. Competency of evidence. Evidence is competent when it is not excluded by the Constitution, the law, or rules on evidence in a particular case. Example of rules are 1. Best Evidence Rule, Section 3, Rule 130. Parole Evidence Rule, Section 9, Rule 130. Hearsay Evidence Rule, Section 27, Rule 130. Offer of compromise as evidence against offerer, Section 27, Rule 130. Number 5, disqualification of witnesses by reason of mental incapacity or immaturity, Section 21, Rule 130. 6, disqualification by reason of marriage, Section 22, Rule 130. Number 7, disqualification by reason of death or insanity of adverse party, Section 23, Rule 130. Number 8 is disqualification by reason of privileged communication, Section 23, Rule 130. And 9, exclusionary provisions in the Constitution. Admissibility of void documents. Evidence is admissible when it is relevant to the issue and is not excluded by the law of these rules. There is no provision in the rules of evidence which excludes the admissibility of a void document. Hence, a void document is admissible as evidence because the purpose of introducing it as evidence is to ascertain the truth respecting a matter of fact, not to enforce the terms of the document itself. Tan versus Hosanna, GR 190-846, February 3, 2016. Rules of exclusion versus exclusionary rules. Under rules of exclusion, these are rules of exception to the general of admissibility of all that is rational and probative. Under exclusionary rules, these are commonly used for evidence excluded by the Constitution. Types of admissibility. Number 1, multiple admissibility, where the evidence is relevant and competent for two or more purposes. Such evidence may be admitted for any or all purposes for which it is allowed. An item of evidence may be logically relevant in several aspects, leading to distinct inferences, or as bearing upon different issues. In this situation, the normal practice is to admit evidence only for the allowable purpose. That is, or example, confession of the accused may not be competent against his co-accused, being hearsay in nature, but may be admitted as evidence of his own guilt. Number 2 is conditional admissibility, relevance and materiality not apparent when offered, but which will readily be seen when connected to other evidence. It is usually permitted upon the assurance, expressed or implied, that he will connect up the tendered evidence by proving, in the later progress of the case, the missing facts. Number 3, curative admissibility, where improper evidence was admitted over the objection of the opposing party, he should be permitted to contradict it with similar or improper evidence. This evidence is introduced to cure, contradict, or neutralize the improper evidence introduced by the other party. Note that this protection is not extended on appeal if he did not object. Exclusionary rules in the Constitution. The exclusion of evidence illegally seized being not admissible is the only practical means of enforcing the constitutional injunction against unreasonable searches and seizures. Applicable provisions of the 1987 Constitution, Section 2, Article 3. Right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable. Section 3, Article 3. Privacy of communication and correspondence shall be inviolable. Number 2. Any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in any proceeding. Number 3. Section 12, Article 3. Any person under investigation for the commission of an offense shall have the right to be informed of his right to remain silent and to have competent and independent counsel of his own choice. If the person cannot afford the services of a counsel, he must be provided with one. No torture, force, violence, threat, intimidation, or other means which vitiate the free will shall be used against him. Number 3, any confession or admission obtained in violation of this or Section 17 hereof shall be inadmissible in evidence against him. Number 4, Section 17, Article 3. No person shall be compelled to be a witness against himself. Doctrine of the fruit of the poisonous tree. The libertarian exclusionary rule known as the fruits of the poisonous tree provides that once the primary source, the tree, is shown to have been unlawfully obtained, any secondary or derivative evidence, the fruit, derived from it is also inadmissible. Stated otherwise, illegally seized evidence obtained as a direct result of the illegal act, whereas the fruit of the poisonous tree is the indirect result of the same illegal act. The fruit of the poisonous tree is at least once removed from the illegally seized evidence, but it is equally inadmissible. The rule is based on the principle that evidence illegally obtained by the state should not be used to gain other evidence because the originally illegally obtained evidence taints all evidence subsequently obtained. The test is also known as but for test. But for test. That is, test whether or not the evidence could not have been obtained but for the illegal action of the police. That said, it does not apply if it is inevitably discovered by law enforcement authorities by sources independent of the illegal search or seizure. On search incidental to lawful arrest. To protect the people from unreasonable searches and seizures, Section 3, Number 2, Article 3 of the 1987 Constitution provides that evidence obtained from unreasonable searches and seizures shall be inadmissible in evidence for any purpose in any proceeding. One of the recognized exemptions to the need of a warrant before a search may be effected is a search incidental to a lawful arrest. In this instance, the law requires that there first be a lawful arrest before a search can be made. The process cannot be reversed. That is in Reyes versus CA. Admissibility of electronic evidence. Number 1, complies with the rules on admissibility provided in the rules of court, and number 2, authenticated in the manner prescribed by rules on electronic evidence. Rules on electronic evidence, Rule 3, number 2. For this, you can listen to my separate upload on rules on electronic evidence. On bank accounts, under Section 2 of RA number 1405, also known as the Bank Secrecy Act of 1955, all deposits of whatever nature with banks or banking institutions in the Philippines are considered as an absolutely confidential nature and may not be examined, inquired, or looked into by any person, government official, bureau, or office, except in cases where the money deposited or invested is the subject matter of the litigation. The inquiry into bank deposits allowable under RA number 1405 must be premised on the fact that the money deposited in the account is itself the subject of the action. BSB Group versus Go. Nothing in RA 1405 provides that unlawful examination of bank accounts will make the evidence inadmissible, but will only subject the offender imprisonment of not more than 5 years or fine upon conviction. Ejercito versus Sandiganbayan. On birth records, Section 3, Rule 128 of the Revised Rules on Evidence provides that evidence is admissible when it is relevant to the issue and is not excluded by the law or these rules. Rule 24, Administrative Order Number 1, Series of 1993, only provides for sanctions against persons violating the rule on confidentiality of birth records, but nowhere does it state that procurement of birth records in violation of said rule would render said records inadmissible in evidence. Tolentino versus Mendoza. Question. A, during trial for the crime of robbery against him, confessed to the crime of robbery against D. Together with his confession is the fact that he implicated B and C as his co-accused, and that they conspired to commit robbery against D. Will the confession admissible against B and C as lone proof of conspiracy between A, B, and C, or against A? Answer to letter A. The confession of A during trial has three purposes to it. Number 1, that A committed the crime. Number 2, that A committed the crime with B and C. And 3, that A, B, and C conspired to commit the robbery. Letter A. Will the confession admissible against B and C? The answer is no. A confession of the accused may not be competent as against his co-accused, being hearsay as to the latter. As B and C are not the accused in the criminal action where A is charged against, there could be no way for B and C to cross-examine this confession and hence would fall under hearsay evidence which is inadmissible against B and C. As lone proof of conspiracy between A, B, and C, the answer is no. The confession of A in furtherance of conspiracy between him and B and C may not be received in evidence without the conspiracy being established by other evidence, as provided in Section 31st or 31, Rule 130. As to letter C, the answer is yes, in the question against A, because he's the one making the confession. While the testimony of A may not be received in evidence for the purpose of proving the conspiracy or as evidence against B and C, it may be received as evidence of his guilt. The normal practice in the situation wherein evidence is made for multiple purposes is to admit the evidence only for the allowable purpose. Section 4. Relevancy, collateral matters. Evidence must have such a relation to the fact in issue as to induce belief in its existence or non-existence. Evidence on collateral matters shall not be allowed except when it tends in any reasonable degree to establish the probability or improbability of the fact in issue. Collateral matters are defined as those that are outside the controversy or are not directly connected with the principal matter or issue in dispute, as indicated in the pleadings of the parties. Logical connection test in collateral matters. Whether the evidence is admissible to show a collateral fact or where preferred evidence is relevant to a collateral issue. Is it admissible? They are generally not allowed, but however admissible when they tend in any reasonable degree to establish the probability or improbability of the fact in issue. Facts in issue and facts relevant to the issue. Differentiate. Facts in issue, these are facts which a plaintiff must prove in order to establish his claim, and those facts which the defendant must prove in order to establish a defense set up by him. Facts relevant to the issue, these are facts which render probable the existence or non-existence of a fact in issue or some other relevant fact. Question. In a criminal charge for theft against X, the defense presented as evidence a marriage certificate as proof that X is married to the complainant A, his wife. Counsel for A objected to the evidence on the ground of relevance. Should the marriage certificate be admitted as evidence? Yes, despite the fact that the presentation of marriage certificate is not directly connected with the issue in dispute, that is whether X committed the crime of theft. The marriage certificate may be admitted as evidence as a collateral matter, as it tends, in any reasonable degree, to prove a fact in issue. Article 332 of the Revised Penal Code exempts from criminal liability from theft committed by spouses, ascendants, and descendants or relatives by affinity. Here, the marriage certificate is proof of the fact that X is married to A, and hence would exonerate the former from criminal liability. Rule 129. What need not be proved? Mandatory judicial notice. Number 1. Judicial notice when mandatory. A court shall take judicial notice without the introduction of evidence of the existence and territorial extent of states, their political history, forms of government, and symbols of nationality, the law of nations, the admiralty and maritime courts of the world and their seals, the political constitution and history of the Philippines, the official acts of legislative, executive, and judicial departments of the national government of the Philippines, the laws of nature, the measure of time, and the geographical divisions. Judicial notice is the cognizance of certain facts which judges may properly take and act upon without need of proof. It is based on considerations of expediency and convenience and displaces the necessity of evidence on a settled matter to save time, labor, and expense in introducing such evidence. It displaces evidence being equivalent to proof. Judicial notice fulfills the objective which evidence intends to achieve. Note, judicial notice is not equivalent to judicial knowledge. A fact may be of judicial notice and not of a judge's personal knowledge and vice versa. Judicial notice fulfills the objective which the evidence intends to achieve. It is the cognizance of common knowledge. Judicial knowledge is that which is based on the personal knowledge of the court. The following need not be proved. 1. Immaterial allegations. 2. Facts admitted or not denied, provided they have been sufficiently alleged. Number 3. Agreed and admitted facts. Number 4. Facts subject to judicial notice. 5. Facts conclusively presumed or disputably presumed but uncontradicted. Matters of mandatory judicial notice. 1. Existence and territorial extent of states. 2. Their political history, forms of government, and symbols of nationality. Number 3. Law of nations. 4. Admiralty and maritime courts of the world and their seals. 5. Political constitution and history of the Philippines. 6. Official acts of legislative, executive, and judicial departments, national government of the Philippines. This is the new rule. Number 7. Laws of nature. 8. Measure of time. 9. Geographical division. The law of nations is the compilation of rules which by common consent of mankind have been acquiesced in as law. Foreign municipal laws, general rule. Foreign laws may not be taken judicial notice of, and they must be proved as any other fact. They do not prove themselves, nor can courts take judicial notice of them. They must be alleged and proved. They may be evidence in accordance with Section 24, Rule 132 as an official record. Exceptions: foreign statute accepted by the government, and number 2, common law. Question: suppose a foreign law was pleaded as part of the defense of the defendant, but no evidence was presented to prove the existence of said law. What is the presumption to be taken by the court as to the wordings of said law? It takes the doctrine of processual presumption. The presumption is that the wordings of the foreign law are the same as the local law. Doctrine of processual presumption. Northwest Orient Airlines versus CA. The doctrine of processual presumption lays down the presumption that the foreign law is the same as the law of the forum. It arises if the foreign law, though properly applicable, is either not alleged, or if alleged, is not duly proved before a competent court. When parties in a case agree on that the foreign law provides, these are admissions of fact which the other parties in the court are made to rely and act upon. Hence, they are in estoppel to subsequently take a contrary position. Philippine Commercial and Industrial Bank versus Exclusion et al. Discretionary Judicial Notice. Section 2. Judicial Notice when discretionary. A court may take judicial notice of matters which are of public knowledge or are capable to unquestionable demonstration or ought to be known to judges because of their judicial functions. A court may take judicial notice of matters which are 1. Of public knowledge, or 2. Capable of unquestionable demonstration, or 3. Ought to be known to judges because of their judicial functions. Requisites of judicial notice. 1. The matter must be one of common and general knowledge. Number 2, it must be well and authoritatively settled and not doubtful or uncertain. And 3, it must be one which is not subject to a reasonable dispute, and that is either A, generally known within the territorial jurisdiction of the trial court, or B, capable of accurate and ready determination by resorting to sources whose accuracy cannot reasonably be questionable. Note, the principal guide in determining what facts may be assumed to be judicially known is that of notoriety. The test of notoriety is whether the fact involved is so notoriously known as to make it proper to assume its existence without proof. There must be unconditional acceptance by the public, or the segment of the public where the fact is of relevant importance. The fact that a belief is not universal is not controlling, for it is seldom that any belief is accepted by everyone. It is enough that the matters are familiarly known to the majority of mankind or those persons familiar with a particular matter in question. Republic versus CA. When is a matter considered common knowledge? There are those matters coming to the knowledge of man generally in the course of ordinary experiences of life, or they may be matters which are generally accepted by mankind as true and are capable of ready and questioned demonstration. Note, thus facts which are universally known and which may be found in encyclopedias, dictionaries, or other publications are judicially noticed, provided they are of such universal notoriety and so generally understood that they may be regarded as forming part of the common knowledge of every person. A court, however, cannot take judicial notice of any fact, which in part is dependent on the existence or non-existence of a fact of which the court has no constructive knowledge. Judicial notice of records of another case previously tried. How about that? General rule, courts are not authorized to take judicial notice of the contents of the records of other cases, even when such cases have been tried in the same court and pending before the same judge. People versus Hernandez. Exceptions, when at the initiative of the judge or of the parties and without objection of any party, the records of the previous action are read and adopted into the present action, or attached to the records of the present action by court order. Number 2, when the original record of the other case or any part of it is actually withdrawn from the archives at the court's discretion upon the request or with the consent of the parties and admitted as part of the record of the pending case. Chumamul versus Cafe. 3, when the present action is closely interrelated to another case pending between the same parties. Number 4, when the interests of the public in ascertaining the truth are of paramount importance. Number 5, in cases seeking to determine what is a reasonable exercise of discretion or whether or not the previous ruling is acceptable in a case under consideration. And number 6, when there is finality of judgment in another case that was previously pending determination and therefore res judicata. Herrera, Remedial Law, Book 6, 1999. Note, the exceptions are applicable only when the case is clearly referred to or the original or part thereof are actually withdrawn from the archives and admitted as part of the record of the case then pending. The appreciation of one judge of the testimony of a certain witness is not binding on another judge who heard the testimony of the same witness on the same matter. Each magistrate who hears the testimony of a witness is called upon to make his own appreciation of the evidence. It is therefore illogical to argue that because one judge made a conclusion in a certain way with respect to one or more of the accused, it is necessarily dictates that the succeeding judge who heard the same case against the other accused should automatically make the same conclusion. People versus Langit. Judicial notice of municipal ordinances. Inferior courts should take judicial notice of municipal or city ordinances in force in their territorial jurisdiction. MTCs are required to take judicial notice of the ordinances of the municipality or city wherein they sit. The RTC should take judicial notice of municipal ordinances only when 1. They are expressly authorized by statute. 2. On appeals of decisions by the inferior court when such courts had taken notice of a municipal ordinance. Letter C. Rules before appellate courts. 1. An appellate court is without authority to take into consideration the judicial records of a case previously decided by the trial court upon which said court did not have the opportunity to pass. Number 2. An appellate court cannot consult the records in another case to ascertain facts not shown by the records of the case before it, but could go to its other decisions for the law that is determinative or applicable to the case under review. Okay, I repeat. An appellate court cannot consult the records in another case to ascertain a fact not shown by the records of the case before it, but could go to its other decision for the law that is determinative of or applicable to the case under review. Number 3, the Supreme Court can also take judicial notice of its records in a previous case in connection with the conduct of litigant or witness in a similar matter. And number 4, lower courts from the CA down to the lowest level must take judicial notice of decision of the Supreme Court, as they are in fact duty-bound to know the ruling of the high tribunal and to apply them in the adjudication of cases, they being part of the legal system. Judicial notice of other matters. 1. The trial court can take judicial notice of the general increase in rentals or real estate, especially of business establishment. Katungal versus Howe. Number 2. A court cannot take judicial notice of an administrative regulation or a statute that is not yet effective. Number 3. In the age of modern technology, the court may take judicial notice that business transactions may be made by individuals through teleconferencing. However, there is no judicial notice that one was conducted in a particular case. Expert Travel and Tours versus Court of Appeals. Number 4, the court has likewise taken judicial notice of the Filipinas' inbred modesty and shyness and her antipathy in publicly airing acts which blemish her honor and virtue. Number 5, it is a matter of judicial knowledge that persons have killed or committed serious offenses for no reason at all. People versus CETA. Judicial notice when necessary. Section 3. Judicial notice when hearing is necessary. During the pre-trial and the trial, the court motu proprio or upon motion shall hear the parties on the propriety of taking judicial notice of any matter. Before judgment or on appeal, the court motu proprio or upon motion may take judicial notice of any matter and shall hear the parties thereon if such matter is decisive of a material issue in the case. When hearing is necessary, this is the new rule. 1. During pre-trial and trial, the court motu proprio or upon motion shall hear the parties on the propriety of taking judicial notice of any matter. Number 2. Before judgment or on appeal, the court motu proprio or upon motion may take judicial notice of any matter and shall hear the parties thereon if such matters is decisive of a material issue in the case. What is the purpose of hearing? Not for the presentation of evidence, but to afford the parties reasonable opportunity to present information relevant to the propriety of taking such judicial notice or the tenor of the matter to be noticed. Mandatory judicial notice versus discretionary judicial notice. Under mandatory judicial notice, court is compelled to take judicial notice. Takes place at court's own initiative and there is no hearing. Under discretionary, court is not compelled to take judicial notice, motu proprio or upon motion, and needs hearing. In People versus Tundag, the court ruled that judicial notice of the age of the victim is improper. Despite the defense counsel's admission thereof, acceding to the prosecution's motion, as required by Section 3 of Rule 129, as to any other matter such as age, a hearing is required before court can make judicial notice of such fact. Judicial admission. Section 4. Judicial admissions. An admission, oral or written, made by the party in the course of the proceedings in the same case does not require proof. The admission may be contradicted only by showing that it was made through palpable mistake or that the imputed admission was not, in fact, made. Judicial admission is an admission, verbal or written, made by a party in the course of the proceedings. Elements. 1. The same must be made by a party to the case. Number 2. The admission must be made in the course of the proceedings in the same case. And 3. There is no particular form of an admission. It may be written or verbal. Judicial admissions versus extrajudicial admissions. Under judicial admissions, those made in the course of the proceeding in the same case. They do not require proof and may be contradicted only by showing that it was made through palpable mistake or that no such admission was made. Their judicial admissions need not be offered in evidence since it is not evidence. It is superior to evidence and shall be considered by the court as established. Under extrajudicial admission, those made out of court or in a judicial proceeding other than the one under consideration. Regarded as evidence and must be offered as such, otherwise the court will not consider it in deciding the case, and it requires formal offer for it to be considered. It is rebuttable. It is not admissible if self-serving, and it's not subject to cross-examination, while in judicial admission, it is conclusive upon the admitter. It is admissible even if self-serving, and it is subject to cross-examination. Note Lack of jurisdiction over the subject matter cannot be admitted because jurisdiction over the subject matter is conferred by law and not by stipulation of parties. Judicial admissions may be made in 1. The pleadings filed by the parties. 2. In the course of the trial, either by verbal or written manifestations or stipulations. 3. In other stages of the judicial proceedings, as in the pre-trial of the case. 4. Admissions obtained through depositions, written interrogatories, or requests for admissions. Judicial admission can be made by either a party or counsel. Note, 2 situations in criminal cases. If it is a criminal case undergoing trial, the judicial admission by counsel can be received in evidence against the conformity of said defendant or even without his conformity. 2. In the course of pre-trial conference, any admission must be reduced in writing and signed by both the defendant and his counsel before the admission can be received in evidence, and that is under Rule 118, Section 2. What is the remedy of a party who gave a judicial admission? 1. In case of a written judicial admission, motion to withdraw the pleadings, motion or other written instrument containing such admission. 2. In case of an oral judicial admission, counsel in open court may move for the exclusion of such admission. What are the remedies on the amended pleadings? Admissions in superseded pleadings may be received in evidence against the pleader, Section 8, Rule 10. Such admissions are considered as extrajudicial admissions. The original pleading must be proved by the party who relies thereon by formally offering it in evidence, and that is in the case of Torres versus CA. Judicial admissions are always conclusive upon the admitter and do not require formal offer as evidence, unlike the case of extrajudicial admissions. Facts alleged in a party's pleading are deemed admissions of that party and are binding upon him, but this is not an absolute and inflexible rule. An answer is a mere statement of fact, which the party filing it expects to prove, but it is not evidence. Rule on dismissed pleadings. Admissions made in pleadings that have been dismissed are merely extrajudicial admissions. Note, not all allegations or admissions in pleadings in civil cases may be considered as judicial admission because the rules on civil procedure allow a litigant to make hypothetical admissions in his pleadings, such as 1. When a defendant sets up affirmative defenses in his answer, or 2. When a defendant files a motion to dismiss based on lack of jurisdiction. Judicial admissions are made in one case are admissible at the trial of another case provided they are proved and are pertinent to the issue involved in the latter. Unless A. the said admission were made only for the purpose or purposes of the first case, as in the rule of implied admissions and their effects under Rule 26. Letter B. The same were withdrawn with the permission of the court thereon, or C. the court deems it improper to relieve the party therefrom. Rules on pleadings not filed. 1. If signed by the party, the admission contained in the pleading is considered as an extrajudicial admission. 2. If signed by the attorney, it is not admissible. An attorney has authority to make statements on behalf of his client only in open court or in a pleading actually filed. Is the self-serving rule applicable to judicial admissions? The answer is no. The self-serving rule, which prohibits the admission or declaration of a witness in his favor, applies only to extrajudicial admissions. If the declaration is made in open court, such as raw evidence and said, and is not self-serving, it is admissible because the witness may be cross-examined on that matter. However, whether it will be credible or not is a matter of appreciation on the part of the court. Are judicial admissions made by the accused during his arraignment binding upon him? The answer is no. A plea of guilty entered by the accused may be later withdrawn at any time before the judgment of conviction becomes final. Such plea is not admissible in evidence against the accused and is not even considered as an extrajudicial admission. Are admissions made during a pretrial in a civil case considered as judicial admissions? The answer now is yes. Admissions made in the pretrial are deemed judicial admissions because they are made in the course of the proceedings of the case. Admissions in civil case versus admissions in criminal case. Under admissions in civil cases, admissions in a pleading which had been withdrawn or superseded by an amended pleading are considered extrajudicial admission. While in admissions in criminal cases, admissions during arraignment may be withdrawn at any time before the judgment of conviction becomes final, but such plea of guilty later withdrawn is not admissible in evidence against the accused who made the plea. It is not even considered an extrajudicial admission. What are the consequences of judicial admissions? 1. A party who judicially admits a fact cannot later change that fact, as judicial admissions constitute waiver of proof. Production of evidence is dispensed with. Number 2. No evidence is needed to prove a judicial admission, and it cannot be contradicted unless it is shown to have been made through palpable mistake or that no such admission was made. Judicial admissions may be contradicted only when it is shown that it was made through palpable mistake. Number 2, the imputed admission was not, in fact, made. This is also under the new rule. Rule 130, Rules of Admissibility. Section 1, Object as Evidence. Objects as evidence are those addressed to the senses of the court. When an object is relevant to the fact in issue, it may be exhibited to, examined, or viewed by the court. Object evidence is that which is addressed to the senses of the court. It is not limited to view of an object. It extends to visual, auditory, tactile, gustatory, and olfactory. Physical evidence is a mute but eloquent manifestation of truth, and it ranks high in our hierarchy of trustworthiness evidence, where the physical evidence should prevail. Bank of the Philippine Islands versus Reyes. Object evidence is also known as 1. Real evidence, 2. Demonstrative evidence, 3. Autoptic preference, and 4. Physical evidence. Real evidence may be direct, can prove directly to the fact for which it is offered. Example, in a personal injury case, the direct real evidence of disfiguring injury would be an exhibition to the court of the injury itself. Now, the second is circumstantial. Facts about the object are proved as the basis for an inference that other facts are true. Example, in paternity case, a baby may be shown and asked to compare its appearance with that of the alleged father. If they look alike, the court may then draw an inference that the parental relationship exists. Requisites of admissibility. 1. The object must be relevant to the fact in an issue. Number 2. The object must be authenticated before it is admitted. Number 3. The object must not be hearsay. Number 4. The object must not be privileged. And number 5. It must meet any additional requirements set by law. Example, it must not be the result of an illegal search and seizure. Authentication. To be admissible in evidence, the object sought to be offered must be shown to have been the very same thing in issue and is what it is claimed to be. Even though the object evidence may contain false information such as falsified books kept by the defendant, it is authentic insofar as it is introduced by the prosecution for the purpose of showing falsity. Purpose of authentication. To prevent the introduction of an object different from that one testified about. Number 2, to ensure that there has been no significant changes in the object's condition. Object evidence includes 1. Any article or object which may be known or perceived by the use of the senses. Number 2, examination of the anatomy of a person or any substance taken therefrom. Number 3, conduct of tests, demonstrations, or experiments. And 4, examination of representative portrayals of the object in question. Example like maps and diagrams. And again, thank you so much for subscribing, for listening, and for sharing. If you're not yet subscribed to our channel, go ahead and hit that subscribe button. I will be reading the part 2 shortly after.